Chair recognizes the honourable member for Fox Hill.
Thank you, Mr. Speaker. I have two communications, one on immigration and the other on foreign affairs. So I should begin with immigration. Mr. Speaker, I would first like, however, to extend my condolences to the family of Colin Callender, who sadly passed away a couple of days ago. I knew him socially and found him to be always quite an upfront and frank individual, and always enjoyed his company. He's one of the senior members of the bar, and I last had the opportunity to speak with him at the home of Lady Eugenie Nuttall in Old Fort Bay at dinner, and he talked about how he was recovering from his illness and thought he was on the way and on the mend. So it's very sad that a man at 74 has passed away, and I wish to pass condolences to him and to his family. Mr. Speaker, I wish to respond on the following subjects that have been raised in connection with immigration operations in the Bahamas over the past weeks that have become matters of public discussion, largely driven, in this minister's view, by a clever campaign of deception, exaggeration, and misinformation, driven mainly from the Grand Bahama Human Rights Association and its spokesman in the press. First, the case of Matthew Sewell. On the 16th of October, the following statement was released by the Grand Bahama Human Rights Association, and I quote, "After 9 years of false imprisonment by both Her Majesty's prisons and the Department of Immigration, the Supreme Court of the Bahamas ordered the Jamaican Matthew Sewell be granted his freedom immediately. In securing this tremendous victory, Sewell's attorney, Grand Bahama Human Rights President Fred Smith, QC, urged the court to recognize that there was no Guantanamo Bay in the Bahamas where individuals can be held in secret and outside the scope of the law." And I skip over some of it, and then Matthew Sewell was reportedly detained in connection with a series of alleged and trumped-up charges over the better part of the last decade. This included a trumped-up murder and house break-in, which happened while he was already in prison. And if you remember, Mr. Speaker, the headlines then said something about trumped-up charges. Here's what the record of the Bahamas Correction Department reflects. Matthew Sewell was first admitted into Her Majesty's prison on the 23rd of June, 2006, on a warrant of remand from the Magistrates Court number 11 for the offense of attempted unlawful sexual intercourse. His warrant was he was further remanded until the 30th of June, 2006. On the 5th of December, 2007, while housed in the maximum security unit, he lost 6 weeks' privileges for fighting with inmates, Alvin Ramsey and John Zervos, on the 25th of September, 2007, by a disciplinary inmates tribunal. On the 4th of February, 2008, he was committed to the Supreme Court for the next session for Magistrates Court number 11 for the offense of unlawful sexual intercourse. On the 1st of May, 2008, he was released by a court on bail bond in the amount of $7,000 from Magistrates Court number 11. Matthew Sewell was readmitted into Her Majesty's prison on the 9th of April, 2009, on a warrant of remand from the Magistrates Court number 1 for the offense of rape. His warrant was further remanded until the 15th of April, 2009. On the 9th of April, 2010, he was committed to the Supreme Court for the next available sitting from Magistrates Court number 5 for the offense of rape. He was released by a court on the 23rd of August, 2013. On the 16th of October, 2013, he was readmitted into Her Majesty's prison on a warrant of remand from the Magistrates Court number 5 for the offense of housebreaking, stealing, and receiving. He was released by the court on the 19th of December, 2013. On the 1st of April, 2014, Matthew Sewell was readmitted into Her Majesty's prison on a warrant of remand from Magistrates Court number 5 for the offense of housebreaking and stealing. He was released on the 3rd of April, 2014. Matthew Sewell was readmitted in the Bahamas Department of Correctional Services, formerly Her Majesty's prison, on the 11th of August, 2014, on a warrant of remand from the Magistrates Court number 11 for the offense of rape. This warrant was further remanded until the 18th of August, 2014. On the 30th of September, 2014, he was committed to the Supreme Court for the next available sitting for Magistrates Court number 5 for the offense of rape. He received a summons from the Supreme Court Criminal Division to appear before the Honourable Justice Bernard Turner on the 17th of October at 10 a.m. And on the 17th of October 2014, he received a Supreme Court warrant for the offense of rape. On the 31st of October 2014, he received a certificate of discharge from the Supreme Court Criminal Division stating that the proceedings against him were discontinued by the Attorney General in respect of the charge of rape and discharged before Mr. Justice Turner. And he was released on the 3rd of November 2014 into the custody of the Department of Immigration. And that's when the detention center period begins. Now, Mr. Speaker, there are reports of various medical complaints while he was in the prison, most of which are related to normal prison conditions where men are at close quarters in confined spaces over long periods of time. But the prison report to me and to the Minister of National Security ends by saying, quote, there are no records of Mr. Sewell making any reports of abuse by inmates or abuse of powers by any staff member. So while he was in prison, there are no records of the gentleman making any reports of abuse by inmates or abuse of powers by any staff member. Here's what the judge had to say in ordering Mr. Sewell's release in a judgment written on the 19th of November. We have complied with the judgment, and a follow-up is being done as I speak to be sure that he leaves the Bahamas. The operative points I wish to make here, Mr. Speaker, are that first, contrary to the public statement, there was no finding by the judge in the judgment that Mr. Sewell had been falsely imprisoned, which, of course, is a term of art. False imprisonment means something in law. There's no finding in that judgment that he was falsely imprisoned. That's the first thing. At paragraph 6 of the judgment, the judge says, and I quote, the committal order is at the heart of the applicant's case. This statement is important, Mr. Speaker, because it is the linchpin on which the case was decided, nothing else. The judge then examined a document which was supposed to have been a committal order and decided that the order did not exist in law and therefore was null and void and not the proper authority on which to hold the detainee. The judge then said at paragraph 14, and I quote, the immediate concession by the Crown was that there was no Regulation 19.4. There is a Section 19.4 of the Act which addresses illegal landing by ship or aircraft. 2, the time that the applicant was to be held in detention is unknown. And paragraph 14 then says these concessions are sufficient to declare the detention order defective. It is nevertheless helpful to expound further on the authority of the Immigration Department to arrest and detain a person pending deportation. End of quote. And then later, the judge says the following in paragraph 22, in all the circumstances, as a result of the deficiencies in the document relied on as constituting the authority under which the applicant was detained, no lawful cause of detention is shown on the return of the writ of habeas corpus. A writ of habeas corpus is therefore issued relative to the applicant. So the decision was made based on the defectiveness of the document. Mr. Speaker, the operative point I wish to make here, and why it took so long to respond fully to this misinformation spread by the QC, is that I wanted to read and examine the judgment for myself and be advised. The matter of what to do going forward, whether by appeal or otherwise, is for the Attorney General, but it seems to me that these observations are obtained from the judgment. Nowhere does the judge say that the charges against Mr. Sewell, which saw him spend time in jail over a period of 8 years, did the judge say that the charges were, quote, trumped up, as Mr. Smith alleges. That is purely an expression from Mr. Smith, which in his deliberately misleading way is then parroted around the world as emblematic of what happens in the Bahamas. As a matter of fact, the only period of detention at issue here was the 1 year or so that the individual spent in the Immigration Detention Center, where he was detained because he had no legal status in the Bahamas, and not 9 years as contrary to what has been wrongly stated by his counsel. Secondly, I am advised that there is no record of the detainee complaining of abuse in the prison at any time during the detention, as I said before, none from the prison and none from the detention center. This goes to the credit of the assertions by the detainee now being made after the fact. Thirdly, the decision in the Sewell case, it appears, was made purely on the document before the judge, which the Crown had already conceded was defective. Everything else said in the case, I'm advised, was not strictly necessary to the decision before the judge, and therefore is what lawyers would call obiter dictum and not part of the ratio of the case. Indeed, another QC similarly opined this matter in the press of the Bahamas. If this is correct, then what is said on immigration law and its interpretation is not binding universally in the Bahamas. In any event, it would apply only to the facts of this case. And even the judge himself says in his judgment it was not necessary to dispose of the case. Mr. Smith has trumpeted this decision as groundbreaking and revolutionary in Bahamian law. I do not agree. The law remains the same as it has always been. The Immigration Department is responsible for the decisions on who is lawfully in the Bahamas and who is not. Those decisions are sometimes reviewable, but in administrative law, the principle is well known that the review body does not normally substitute its decisions for the adjudicating authority unless it is manifestly unreasonable. The leading case in Bahamian law is one I've quoted before in this House, Ryan and the Attorney General, and his authority for that proposition. This gross exaggeration on the part of Mr. Smith and his partisans is but one of a number of examples of irresponsible and rash claims being made. You will recall his publicly comparing the work of the Immigration Department to Auschwitz in the Bahamas. Auschwitz was a concentration camp used in the Second World War by Nazis to kill Jews. There is no evidence of any such similar activity in the Bahamas. In the press release the QC issued with regard to the Sewell case, he talked about Guantanamo in the Bahamas, no doubt seeking to change the first irresponsible rhetoric, knowing how stupid and irresponsible it was to say something so repugnant. But with respect, there is no evidence of any such Guantanamo in the Bahamas. Indeed, his case shows that there is no secret lockup. The very case that he's prosecuting shows there's no secret lockup. His client was at all times available, and the case was reviewable. You will also recall that this is the same QC who encouraged illegal migrants to the Bahamas to swamp the courts of the Bahamas with legal actions in an effort to bankrupt the government. It would seem to me that the court should take judicial notice of this and seek to find whether the plethora of claims now being made by the QC are not motivated by money and greed on his part as opposed to the genuine concern for people. I insist that what happened in the Sewell case was an administrative error. I have asked that this not happen again. Once the error was discovered, the case could easily have been disposed of at the stage of the lawyers' conference, and Mr. Sewell could have been sent home. Instead, it was allowed to go on, and of course, court costs were awarded, which will go to Mr. Smith. All of it is unnecessary, but it appears that this lawyer does not have a moral conscience that would point him in that direction. I spoke immediately after the decision with the Foreign Minister of Jamaica to undertake a thorough investigation of the matters and to revert to him with our findings. I give the public my assurance that under my superintendence, any issue of this nature is easily correctable by one phone call from legal counsel, from the consular representative, from a relative, from a concerned citizen, easily correctable. I'm also, Mr. Speaker, developing between the Ministry of Foreign Affairs and the Immigration Department a public affairs unit to deal with the plethora of human rights issues which arise from time to better manage information and the actions of the department and the ministry. There are other statements that have come arising out of legal cases from the same QC, one of which has led to an appeal on an interlocutory order for disclosure, where, in connection with an immigration matter, the courts at first instance ordered the release of all minutes and memorandum connected with the immigration policy of the government with regard to non-nationals in this country, which was implemented on the 1st of November 2014. The policy is working well. Most people have complied. Mr. Speaker, one anecdotal example, I spoke to a teacher in one of our public primary schools who told me that in her class she has 26 students and only 4 are Bahamian. Many of them that many of these students do not know who their parents are. How can this continue unchallenged, that people live and grow in this country with no documentation about who they are and their identity? The policy of the 1st of November 2014 is declarative of the law of the Bahamas, and it should be followed. There's nothing more to say on the matter. However, there's been some criticism because of the decision to appeal. Such a decision cannot be allowed to stand without going to the Privy Council, the policy court, to determine whether the internal ruminations of cabinet ministers and the confidential advice they receive from public servants can ordinarily be subject to disclosure, particularly in a case where the documents may have no relevance to the case at hand, but may be merely a fishing expedition. I have an obligation, I believe, to my successors to ensure that the law is clear on that matter. In a recent statement by the same QC, there was a criticism in response to my concern about the fact that the courts do not appear to have taken notice of the policy change with regard to the penalties on immigration matters. The penalties have been increased across the board to a maximum of 5 years or $10,000 fine for immigration offenses. Yet, in some cases, people have been given $150 fines and allowed to go. That criticism of mine was converted by the QC, who claimed that it was an attempt to control the judiciary. That is foolishness on its face. Parliament has passed a law. No one tells the judiciary what to do, but a mere observation is made that despite the change in penalties, there appears to be no change in sentencing policy, is simply that of an observation and a truism. The legislature and the government have the right to give its views, and this false sanctimoniousness about separation of powers should not be used to deny the point, particularly given who is making the criticism. Finally, Mr. Speaker, there was a case of someone named Jean Gestulien. This man was arrested during an interdiction in Eleuthera following upon an illegal landing. This is a vexing problem for the people of Eleuthera, and we have been fighting to contain it. I am advised that he was released on the charge of illegal landing by the courts. Here is the report of that matter from the Department of Immigration, and I quote, "The above-named Haitian national was arraigned before Magistrate Andrew Forbes on the 23rd of June 2015 and charged with the following offenses: illegal landing contrary to Section 19(1) and 2 of the Immigration Act, Chapter 191, Statute Laws of the Bahamas, Revised Edition. He pleaded not guilty to this offense. He was subsequently remanded to the Bahamas Department of Corrections, and the matter was adjourned to the 24th of September 2015. The matter was substantively heard on the 1st December 2015. At the end of the trial, the magistrate ruled that insufficient evidence was proffered by the prosecution. As a result, the defendant was discharged and acquitted by the court. However, the magistrate ordered that the defendant be surrendered to the Immigration Department for further assessment and possible deportation. The words "for further assessment and possible deportation" are from the magistrate's order exactly as given. The subject, Mr. Speaker, was not born in the Bahamas, has no claim to Bahamian citizenship, had no legal status in the Bahamas, and so has been returned to his country. There's nothing more to say on the matter because I am advised that yet another action has been launched in the courts over this. We are also waiting the result of another matter in Freeport, where the same attorney is fighting the right of immigration to challenge the status of a tourist in the country, and that is being questioned. We await the written ruling, but by order of the court, the subject is being given extensions 7 days at a time to remain in the Bahamas until the ruling is rendered. Mr. Speaker, I say again in these matters that this same attorney advised the illegal migrant population in the Bahamas to flood the courts with legal actions to bankrupt the government. This is the primary ambit, it appears then, of all of these matters. Each day, there's some press release spreading alarm and crying wolf, emanating from the same one spokesman from the Grand Bahama Human Rights Association. Each feeds his practice with a case in law and the hope that costs will be awarded in his favor. That is the clear pattern. Remember the alarm about clearing Gamble Heights, All lawful steps were taken by the government, and the action was completely successful. False alarm, false information again. His two favorite words, unlawful, unconstitutional, and so far, none has panned out. The government welcomes, Mr. Speaker, the minister welcomes the review of any of its policies in a free, open, and democratic society. But we ask for the facts, not exaggerated and often false commentary. I say again, this disinformation is giving aid and comfort to a sophisticated criminal enterprise to breach the borders of this country. And I was just telling the members opposite before the session started that yesterday, migrants from the south of us, again, were interdicted, this time on a fast boat. So we're not dealing with, the regular little sloop. People are paying lots of money to breach the borders of the Bahamas and then move on to the United States. No government or immigration minister can allow it to go unchallenged, and I shall continue to fight for the Bahamas and resist this attempt to breach our borders, to sap the will of immigration officers, and intimidate us all to have our country awash with illegal migrants. Thank you, Mr. Speaker.